Director Black has arrived, and with him is the Muskogee Regional Director, Eddie Streeter, and there to my left. And we also have with us Superintendent Robin Phillips, and we have 1, 2, 3, 4 attorneys from the Solicitor's Office, 2 from Washington, D.C. We have members of our Osage Nation Congress here. We have Congresswoman and Speaker Maria Whitehorn, longtime Congressman Archie Mason. We have Dr. Shah, Huggy Supernaw, John Baker, Angela Pratt, R.J. Walker, and John Yeck is here. And then, of course, I mentioned already Galen. We have and Chairman Waller. Thank you for coming, sir. And we also have Andrew Yates. Attorney General Wells is here. Former Congressman Doug Revard, and Judge Revard is there. We have some oil and gas folks here. I see Osage Paul Revard, whose family goes back to decades. And many others. So if anybody wants to go ahead and sit down and bear with us. We have about an hour and a half. Most of that will be taken by Director Black. I met him in Washington, D.C. just this year, but I met with the staff of Senator Langford and Senator Inhofe. I had previously met with Senator Langford and Senator Barrasso of Wyoming on issues where the Osage government, the Osage Nation, is a participating agency in the rewrite of the environmental impact statement on environmental factors. As most of you know, under this Constitution we operate under, we defer all minerals day-to-day activities to our Minerals Council, and including specifically the leasing and operational agreements. That does not relieve the Osage Nation from assisting them in the matters such as the Section 106 historical preservation matters, which the Bureau Environmental Office gives us a time period to respond. We need to respond promptly to make sure that the drilling and rework, any permitting, does not get unduly delayed. We also have the environmental task of the underground well injection program. And under our government system, we also here have Council Member Cynthia Foon as well. So we have our various duties that we do in-house, and through all that, we have one trustee based on Indian law as established by the United States Supreme Court and announced by Chief Justice John Marshall in the 1830s, and traces its roots from the Constitution of the United States, and even before that, to the Articles of Confederation. And those documents from the federal government say we have a trustee, which is the Congress of the United States. And their relationship is based on treaty and on law. To carry out the duties from the United States of America, several agencies have been created. We had for many years, much too long, the Department of War. And interestingly, Sonny Abbott and others know that the Osage word for superintendent is mahida. And I asked the old folks, why do we call the superintendent Big Knife? And they said, well, in our grandparents' and great-grandparents' time, the superintendent carried a sword. So that history has evolved to where the Department of Interior took over. And then they had the Bureau within it of Indian Affairs. During the 1970s and 80s and through today, The recognition of that trust responsibility has been accomplished through EPA, in our case, Region 6 in Dallas, through the Indian Health Service, continuing through the Bureau of Indian Affairs and other government agencies. But the key is the United States Congress. There has been a lot of discussion of what's been going on with the U.S. Senate. Assistant Chief Redcorn and I have been trying to understand the dynamics in play. I asked Director Black to visit the Osage and explain from one of the perspectives, from, as the Senate calls it, the several stakeholders involved. And the stakeholders involve the Bureau of Indian Affairs, the surface owners, the Osage Nation, the producers. I know there's one I'm forgetting, but you know, this appears to be an evolving list. The Osage Nation government was not part of that list until just a few months ago. And we've been in the dark as a government for much too long. I asked Director Black to appear to explain from their point of view what it looks like with the environmental issues. Most of you are familiar with the 1979 environmental assessment matter, the Donaldson lawsuit as it's called, the permitting issues, or lack of, and the negotiated rulemaking activities, and the orders of Judge Frizzell, and the other issues, which to the new person looks like it's all the same, but it's not. And so I'm asking Director Black and his attorneys to assist from us in helping to understand what's going on so we can make intelligent decisions. So that's what he's agreed to do. He's my guest here, and I appreciate him coming. And there's going to be a question and answer period. And he's ready for that because he's brought these lawyers. So at this time, I'm going to turn it over to the National Director of the Bureau of Indian Affairs, Mike Black.
Thank you, Chief. Well, good morning, everybody. First of all, I'd like to thank you all for coming out this morning, and I'd especially like to thank the Principal Chief for inviting me here today to talk with you all about the various activities that the Bureau of Indian Affairs is involved in here at Osage County. As he stated, I am accompanied by a number of solicitors, or my lawyer, basically Mr. Ken Dalton from Washington, D.C., Mr. Stephen Simpson from D.C., Mr. Chuck Bass from the Tulsa Field Office, and Mr. Alan Woodcock, also from the Tulsa office. And also with me today is Mr. Eddie Streeter, the Regional Director for the Eastern Oklahoma Regional Office, and Ms. Robin Phillips, the Superintendent here at Osage Agency. Despite the several legal challenges that are pending in the courts regarding Osage interests, it's my pleasure to be here to share with you as much as I can, due to the pending litigations, what is happening. As many of you know, there's multiple lawsuits pending that impact the Osage, including the consolidated lawsuits of the Osage Producers Association and the Osage Minerals Council, challenging the Department's final action of revising the regulations that govern oil and gas leasing in Osage County. The Hayes and Donaldson lawsuit, brought by two surface owners against lessees and the BIA, challenging the validity of certain oil and gas leases and permits. Because of questions regarding compliance with the National Environmental Protection Act of 1969, otherwise referred to as NEPA. Another lawsuit brought by the Osage Producers Association, challenging the manner in which BIA has been handling the applications for permits to drill in the context of BIA's NEPA compliance. And also the Osage Wind matter that the United States brought, which seeks a declaratory judgment that the excavation activities of Osage Wind and NL in Osage County, Oklahoma are unlawful because they failed to obtain all the requisite federal regulatory approvals and failed to enter into appropriate leases approved by the Secretary of Interior. And more recently, related to the Osage Wind, is Mustang Run matter where the United States again contends that the ongoing excavation and activities of Mustang Run Wind Energy LLC, Trade Wind Energy, and NL are unlawful and must be suspended until those entities have obtained all requisite federal regulatory approvals and have entered into appropriate leases approved by the Secretary. With that brief context, I want people to realize how constrained we are from discussing the matters that are subject to the pending litigation, and we will be somewhat limited on what questions we will be able to respond to. However, I do wish to point out that as you examine the scope of the issues at stake in these lawsuits, oil and gas production, renewable energy, environmental protection, and etc., you begin to see the complexity of the responsibilities that the department carries. And as you know, many of these responsibilities and others fall to the Osage agency. The chief has asked me to specifically talk to the final rule governing the management of the Osage mineral estate, which revised the regulations at 25 CFR 226, and the efforts to update the environmental impact statement covering Osage County. The rule came out of the Osage Tribal Trust settlement executed on October 14, 2011, in which the department agreed to engage in negotiated rulemaking to revise the oil and gas regulations governing the Osage Minerals Estate in order to improve the management and administration of the Osage Minerals Estate. The rule is a result of the negotiated rulemaking. In the settlement agreement, the Osage identified certain issues that needed to be addressed in the rulemaking, including improvements and technology enhancements for the collection, transmission, and reporting of mineral production and accounting information, appropriate revisions to the methods for calculating royalties and rentals for oil and gas, including but not limited to royalty rates, royalty value or pricing, and rental rates. Best feasible practices for developing and conducting on-site inspection programs, and best feasible practices for gauging oil and gas production and the resources needed to implement strategies selected. The rule sets out new reporting requirements, provides for the ways that oil royalties can be paid, specifies new requirements for gas measurement, changes bonding requirements, adds site security requirements, and enhances inspection authorities, details environmental responsibilities, and increases standards for safety and control of wells, including protection of fresh water and other minerals. In addition, many of the provisions in the rule stem from public comment and concerns voiced throughout the negotiated rulemaking process, including concerns from surface owners and producers. Further, the rule also served to address many of the actions the Interior Inspector General's office recommended be undertaken to more effectively manage the Osage mineral estate. That report was published in October 2014. Regarding the EIS, NEPA review is a requirement for all actions of the federal government. Therefore, because BIA approves leases, APDs, workovers, and other actions involving the Osage mineral estate, NEPA review is required. In 1979, BIA prepared an EA for the oil and gas development at Osage, and has relied on it ever since. In November 2012, prior to any of the litigation, the BIA began to work with BLM to include Osage County in its multi-state EIS effort in order to update the 1979 EA. In the summer of 2014, the BIA accelerated the portion of the NEPA review for Osage County. NEPA regulations require that any actions taken during the preparation of a large-scope EIS have independent NEPA review. Therefore, BIA is currently approving the site-specific EAs to accompany all APDs and approved programmatic EAs for leases and work orders. It's important to note that none of these actions mean that the 1979 EA is inadequate or somehow flawed. Rather, the superintendent's actions are, in the words of the regulations, to further the purposes of NEPA. That is, to make sure that decision makers and the public have the most up-to-date analysis before them. In addition, the new rule and EIS efforts, the BIA has made some significant changes in the agency staffing and operations. You can excuse me a second, I need to drink water. Over the past 2 years, and this results from not only the negotiated settlement, but our own evaluations of our agency operations, as well as also one thing that came out of the settlement was we agreed to 2 consultations per year with the Minerals Council. And part of those discussions was identifying some of the shortfalls and some of the issues we had in our operations and management of the minerals estate. And due to that, over the past 2 years, we've hired an additional 13 staff members at the Osage agency. We've created a new branch of enforcement and lease compliance, which regularly reviews the data to identify leases within 6 months of continued non-production and issue cause letters. We assist producers in environmental assessments for drilling permits. Prepare 2 programmatic environmental assessments, one for the workover operations and one for the leasing operations. And we've also added new staff and resources plus training. So we've had trained all of our petroleum engineering technicians have gone through a PET course that's put on by the Bureau of Land Management. So it certifies our operators, our inspectors and our field staff as PETs. We will continue that effort moving forward to make sure that all of our staff and all of our inspectors are certified out there. And we've also improved our systems and processes for handling information, which includes a complaint tracker, a permit tracker, a high-risk lease inspection strategy, lease inspection tracking system, and a tank strategy. We will continue to work on those improvements over the next, as we move forward in this effort to address not only the tribal trust settlement, but also the Inspector General's report to ensure that we have our staff prepared and are able to best manage the minerals estate for the Osage Nation. With that, Chief, that pretty much concludes my opening statement. I'm open to taking any questions that we're able to answer from anybody. Like I say, we will be somewhat limited by the litigation, but we're open to taking comments and or questions.
Let me ask you the schedule that we're presently on with the environmental impact statement. What does it look like?
I'm going to ask Mr. Simpson to come up and address that for me.
Chief, the reason that Mike is asking me, I'm Stephen Simpson from the Division of Indian Affairs and Solicitor's Office in D.C. The reason why he's asking me to do this is because I'm actually working on the EIS with several members of Robin's staff and Eddie's staff. Currently, we're preparing the draft EIS. The cooperating agencies and entities will probably be getting that somewhere in the next few weeks for review. But it will not be public until probably about mid-October for the draft EIS. So we go through our review of that draft, and then we'll publish it. There is a comment period of about 45 days on the draft. There will be a public hearing. Here in Pawhuska, I think. Yes. During the course of that time. So you all will be able to make comments on the draft. And then we will work on preparing the final. The final EIS is currently scheduled to be issued depending on the level of comments we get and what we have to do to the draft. The final EIS is scheduled to be issued in the early part of 2016, with a record of decision no sooner than 45 days after that final is issued. It can be longer than that. That's the current schedule for
Yes,
Yeah, Mike, on the draft of this BIA, when it's brought out, will it be held up like the negotiated rulemaking thing was? We approved it 2 years ago, and it still hasn't been implemented. Would it be able to be fought the same way, stopped in courts?
Could you repeat the question for the audience?
Okay, I'm sorry. Yeah, what Mr. Abbott is asking is if the EIS, when it is issued, if it will be delayed similar to some of the issues we ran into with the regulations. I honestly couldn't tell you. That would be dependent on what happens after it's made public, whether there's any challenges to it or not. But Mr. Simpson laid out the schedule that we're holding to stick to.
Yeah, there would be no lawsuits over it.
According to Mr. Simpson, there could be no lawsuit until the final order is issued. After the decision, is issued. Yes, ma'am.
I have been a shareholder for quite a few years, And in one, I am a business owner for over 50 years, several businesses. And I sit and watch the way you all have worked this, and I've just been amazed at how the rules and the penalties were put into these rules and regulations. I think that perhaps you didn't give the training beforehand.
It seems to me like the people in the offices made up all these rules and said, oh, well, this sounds good. And one of the Minerals Council, when I complained about this at a meeting, he said, well, we're going to make more money for you. Listen, I heard some rules and penalties that I would not stand for in a business. When the producers were aware of having to pay $500 instead of $50 a day for a penalty, that is ridiculous in the business world. Of course, if you've got to enforce the rules and you've got to add more penalties, okay, but not 10 times more. It just seemed to me that people were making these rules that were not experienced or knew what the poor producers were going to have to go through. And being a shareholder, of course I want to make money, and of course I see what's going on. I get up every morning and watch to see how much the gas is. $1.99 in Tulsa for a gallon, and of course I filled up so I can come up here. I just think that, of course you had meetings. I didn't go to the meetings when they were making these rules because I was not experienced enough in the oil, what the producers and what the council was having to do. But I've been following as closely as I possibly can now. I really think that we've got to think about this. And you're telling me all these different people that are going to be in charge of the BIA and the whatever it is in Washington, and evidently that's more than what we've had before. It seems to me like our Minerals Council and our Osage people can do a whole lot of this rather than have to go to Washington, D.C. and ask them to help us. We should do this ourselves. And I think that our council has gotten more experience and the producers, and we all want to work together because the bottom line of this is we all got to make some money. And I am really upset when I go to the meetings and I see that the BIA just doesn't seem to be working in cooperation with the Osages. Seems like they've got their rules and you all are going to do what we're telling you to do. Don't seem quite fair to me. And I think that we ought to work together, and I think we are all intelligent enough. We've got good, educated people in our tribe that we can do a lot of this ourselves. And I just hate to see it all handed out to Washington and let them tell us what to do. Thank you.
Thank you very much for your comments. Just, the one thing I would respond to is the regulations that you're referring to were developed through the negotiated rulemaking process. I think you referred to that as well.
Yes, I told you I didn't go because I am not experienced. I'm a florist, and I've been a florist for over 50 years. And run my own business. At times I had 5 businesses I was running. So I had to watch everything that was going on. But I was not experienced enough in the oil to go in there and tell you all what I thought. I felt like you all, with our council and with the people that are making the rules, and the producers, everybody, it just seemed like nobody paid any attention to what was going on to me when I'd see those rules coming out. $50 going to $500 penalty. That's stupid.
Thank you. Is there anybody else that has a comment or a question?
I can't hear you.
I'm sorry. Is there anybody else that has a comment or question they'd like to ask the speaker?
Yes. One thing that I looked at through the negotiated rulemaking process was, and I saw that was probably going to impact our county, is the economy. We are an oil economy here in this county, and Mary Lee likes to pay $1.99 for gas, and that's wonderful, but when the price of gas is $3.79, mineral counties, oil-rich counties do much better, their economy throughout. My question is, I think there was a decision made at the first of the negotiated rulemaking that the economic impact of promulgating this rule and working on this rule was not was not at a level that would impact us. Well, I know the price of oil is down. It's impacted us. The producers being scared of what was in the rule has impacted us. Our economy is suffering. I have businesses that surround the oil field, that's a trucking company. It's definitely impacted my business. So I wonder if you or any of the solicitors could speak to the decision that was made, that the economic impact would not be at a level that you would need to do an economic study to work on this rule first.
Unfortunately, that is part of that is one of the issues that is subject of the litigation, and I'm not going to be able to respond to your question. My apologies. But I do appreciate the comment.
Okay, thank you.
I have a comment. I don't understand why the BIA didn't get more involved as the wind farm issue started to arise and lawsuits were coming. Why you all didn't send federal marshals out there to stop and halt what was going on? You had that ability, and you chose not to take that action. And here we sit with wind farms, and they're going. They're there. They're built. We watched one go up. We watched two go up. We watched 20 go up. And now you can see them from 40 miles away from where they sit, from the Hominy Hills. Why was that action not taken?
There again, this is one of those questions I'm going to refer over to my solicitors that are much more deeply involved in this situation, in this case. Maybe Mr. Trushback.
The United States has filed 2 lawsuits against industry and the wind farm companies, alleging that the wind farm companies have not obtained proper approved leases from the Osage Minerals Council, and those are matters that are currently under consideration by the Federal District Court in Tulsa, and we will see what the District Court has to say about those issues, and that's all I can say at this time. It's in active litigation as we speak.
My name is Shannon Duty. I'm the editor of the Osage News. I don't know if you're aware, but there are some proposals circulating from Senators Inhofe and Langford's office about turning over the regulation of the oil and gas mining to the Osage Nation government or the Osage Minerals Council. Are you aware of those documents, and how amenable is your office to turning that regulation over to the Osage Nation?
I am aware that there's been a lot of it is what's in the press down here. But as far as that goes, I haven't seen any of the proposals. I'm not familiar with it. I certainly can't speak for the senators. So I think that'll have to play itself out.
Nobody else.
Good morning, Shannon Edwards, Osage Nation Congress. In that regard, has the Bureau been in contact with the Oklahoma senators who are also discussing the possibility of really, I think, in effect, turning back the 1906 Act and working with the State Corporation Commission? And if you have, can you tell us what the nature of those meetings and negotiations are?
No, we have not had any meetings or negotiations along those lines. I have, throughout this process, maintained contact with the Oklahoma Senate delegation to ensure they're aware of what we're doing out here and the processes and progress we were making. Other than that, that's as far as it's gone.
Mr. Black, comment, you can't comment on this, I'll make a couple comments and a question, but you discussed in great length the negotiated rule process, but this whole audience knows a federal judge turned to the audience, basically, or had the federal attorney turn to the audience and repeat, because when he said he thought the new regs were valuable, and they were not. And you got a big laugh out of the audience saying basically that that whole process was not worthy. Also, we are all aware here, and minus the decline in oil and gas prices, we are all aware here that the oil industry in Osage County has tanked. Monthly, we're losing operators. Charges are that its trustee is responsible for a big portion of this failure. Would you please comment about the failure of the alleged failure of your stewardship of the oil and gas industry and the royalty rights here in Osage County?
I don't know that you call it an alleged failure. I think I identified in my opening statement, that we are taking every step that we can to ensure that we're as best equipped at our agency level to manage the Osage Minerals Estate in accordance with the regulations and our trust responsibility to the Osage.
I repeat, your track record is that you have lost your stewardship doing good stewardship as a trustee. Thank you, Ms. Black.
Nothing personal, but we've about managed the small producers completely out of business. We're on our last leg. 9 or 10 months of really bad prices and all this litigation. Washington, D.C. managing this worn out old county is not doing anybody here any good. It's legitimizing a bunch of jobs, and I'm sorry to have to say that, but our jobs are on the line. We're on our last leg. If you're a small producer in Osage County and you don't think you're on your last leg, you're blind. The paperwork, the letters, it's amazing. It's amazing how complicated it's gotten. And it's Washington, D.C. is managing this thing. We're about out of business. If you're thriving and you're in the oil business, I'd like to see your hand.
Thank you. I appreciate it.
Thank you, Mark. My name is Paul Weingart. I'm a shareholder, Osage shareholder. I'm also an Osage County producer, having been an operator here in Osage County for 38 years now. Concerning the existing production, I operate a lot of marginal wells. I have a few of them that have gone down, not producing today, for simple, ordinary reasons. One is due to a scale buildup downhole, where my downhole pump is stuck. I've pulled it a couple of times and replaced it, but it just sticks again. What I need to do is acidize the formation to clean up the scale, but to do so requires that I fill out a 139 form and receive BIA approval for that, which I cannot obtain today. And this is just for a simple operation to put a barrel a day production back in operation. I've got a few other similar situations. Since the superintendent had issued her order last July that became effective in August, that no new workovers or new drills could be performed without these additional requirements, it's really been detrimental to all us producers and the shareholders from their lack of income from our wells. I would like to know what was the urgency that just on one certain day it became so important to shut everything down. What happened on one given day that we had these new regulations imposed? I understand, that the environmental concern, but couldn't we have phased this in over a period of time? And also, what harm is it for me to go in and acidize a well that I drilled in 1988? The area around the well has been taken care of. Whatever environmental impact that was going to happen to that location has already occurred. It occurred when I drilled the well in 1988. What harm is it for me to go back on the same spot where I've had trucks in and out of for all these years? What harm is it for me to come in and pull a pump out and treat one of my wells on the same land that has been utilized for this purpose for decades? Why can't we, is there something that you can do to at least allow us to work on our existing wells, not new drills, but put our existing wells to help to let us maintain our existing production? Is there something that, you know, that the Bureau of Indian Affairs can do to lessen this restriction so that we can at least keep our existing wells in operation?
First of all, let me just say, it's never has been our intent, and it continues not to be our intent by any way, shape, or form to shut down production or limit your ability to continue operations. We have completed a programmatic EA dealing with the workovers, which is what you're referring to in your statement largely. And other than that, we are subject there again, once again, to some litigation involved in the issues that you're talking about. So it'll be somewhat limited beyond that. But aside from that, we do want to continue to work with the producers to allow you to continue your operations as best we can within the limitations, laws, regulations, statutes that we have to abide by. And one of those being NEPA.
Sir, my name is Jim Revard. I'm with Big Con Supply. Having an open house tomorrow here in Bethesda. If you are welcome to come see our new facility. I was self-employed until the Bureau of Indian Affairs made it impossible to work on oil wells in this county. So my question to you, sir, does the Bureau of Indian Affairs believe they have an obligation to promote oil and gas production in Osage County? And if so, what do you do to encourage production in this county? And if you don't believe that, what is your obligation to the Osage Nation? Another question is, are you here to remove the superintendent from her position? Because this nation, the Mineral Council, voted a vote of no confidence to a superintendent that has no oil and gas knowledge whatsoever. And why is she still in the position she's in?
Let me try to address the first part of that. And as with the Bureau of Indian Affairs and the federal government, for that matter, we have a trust responsibility to the Osage Nation and the Osage Mineral Estate, the head right holders, and the Minerals Council. And as such, that is what our charge is in our, for the protection and further production of the minerals estate, to ensure that we are carrying that out. And as far as the superintendent goes, no, I am not here to remove the superintendent. She has, contrary to what you may believe, she has extensive oil and gas experience.
Can you make her attend our meetings? She refuses to sit in our council meetings. How is she representing us?
I will have those discussions with her. Yes.
Your third regard. I'm Hollywell, Attorney General for the Osage Nation. I feel like it's my obligation to ask you why the wind farms are allowed to continue to be built without proper permits yet. Our oil men are not allowed to continue to drill or maintain their wells without the proper permit. Do you see my question?
I do, I think. Well,
we've got wind farms going up without the proper permits, correct?
That, there again, I think that's all under active litigation. I'm not able to respond directly.
Well, you can see them.
I have seen them.
So you would agree with me they are there?
They are there.
Without the proper permit?
That I can't attest to, but it's under litigation.
Well, who can attest to that? You could maybe speak to me about that.
Right now, I don't know, let me ask Chuck.
I would appreciate that.
In the first lawsuit that we brought, United States versus Osage Wind and other defendants, the construction activities that we were concerned about were completed before the federal district court judge had an opportunity to rule on the United States motion for a preliminary injunction. In the second lawsuit that we filed, which is United States versus Mustang Run, the excavation has not yet begun, and we have asked the court for a preliminary injunction to stop excavation until the court rules in the Osage lawsuit. And we will wait until we see what the federal judge says in the Osage Wind lawsuit before we make any additional arguments on behalf of the United States.
So can these old men out here wait until we see what the judge says before they stop drilling?
Those are two separate issues.
Well, they're not.
They are.
The permits that you're stating have to be completed.
The permits that have to be completed underneath. Well, what we're trying to stop construction in one instance, and you're trying to get oil production started in another instance.
But you're not stopping it.
We're not stopping what?
The construction. They're there.
As I said, in the Osage Wind lawsuit, the construction was already completed. The excavation, which is all we had the ability to try to stop, was already completed by the time the federal judge got to that issue.
So my question is, until the federal judge gets to the issue, can we continue to drill?
I can't speak to what the oil companies can do. They have their own counsel.
I'd like to speak up. I usually don't need a microphone. Why did it take so long to file the lawsuit to stop the windmills, or whatever we want to call them? Also, my second question to you is, you have a fiduciary duty to the Osage people. If you find rules that are punitive to them, do you not have a duty to see that those rules are changed? Thank you.
There again, I'll probably fall back on Chuck and respond to the first part of your question as far as the process to get the litigation filed, if he can respond to anything on that. Regarding, we do have a fiduciary and a trust responsibility to the Osage Nation. Regarding the regulations, again, those are subject to litigation. We can't get into that right now.
The initial litigation against Osage Wind was brought by the Osage Nation, as you may recall. That litigation ended unsuccessfully for the Osage Nation. We worked with the Minerals Council with the time that we had, and we brought the litigation that we brought. And we brought a second one, and we shall see.
Hi. My name is Stephanie Kim. I'm a Osage right owner. My question has to do with the 1906 Act and trust responsibility between the U.S. government, specifically with respect to amendments that have been made to the Act over time. I understand that that's a process that involves an Act of Congress. Is that correct?
Yes, ma'am.
And there have been several made. And my understanding is that one of those, fairly recent one, included the language in perpetuity to update what was a finite period of time for that trust responsibility and make it in perpetuity. So I would like it, if you would, please, to explain what in perpetuity means and whether such definitive language can be changed at this point in time with an amendment.
Well, I'm going to give you an engineer's definition of in perpetuity instead of the lawyer's, and it basically means forever. And in order to change that, the second part of your question is it would take an act of Congress to change that. To change any of the language in the 1906 Act would take an act of Congress.
So the language is not working.
Well, I think the way you phrased it is saying that we have a trust responsibility in perpetuity,
yes.
and that's true. We have that trust responsibility in perpetuity. Unless something is changed in Congress. Excuse me, I've got a question from the Vice Chair. Sorry.
follow up on the General's question. I want to follow up on the question that the Attorney General asked and just ask it a different way. If a field man can stop an oil man from drilling a well that he's not permitted to drill, why couldn't a field man stop a mining operation that has no permit to mine? I think it's the same question she asked, but just taking the litigation out of it, why was the response limited to litigation and not a physical restraint or some kind of immediate action on the part of the field office to stop the mine when the BIA was notified of it?
The Department of Interior sent a demand letter. That's the step that you have to take in order to bring a lawsuit. We asked Osage Wind to stop construction until they had appropriately received a lease from the Osage Minerals Council that was approved with the BIA. Osage Wind wrote us back a letter and told us our legal interpretation of the statute was wrong, and we continued construction. That's when we filed the lawsuit.
You didn't answer my question.
Well, we didn't have the authority to send anyone out there and stop construction. That's why we filed the lawsuit. You can consult your Attorney General to assess it. I've gone as far as I can go.
Director Black, my name is Eddie Red Eagle. I'm a Osage member of the Osage Nation. Director Black, as we can see in the position that we're all in, all parties, we're now tied up in the legal complications that historically the Osage has been tied up many, many times before, as you well know. My question is, in the legal missteps that have led us to this point where the whole county is now tied up, and I say the whole county, not only the tribe, head right holders, producers, but now the impact upon business owners, school tax levies, property prices, property values, everything in Osage County is impacted, and that it's been halted by at least 30%. My comment is, in years past, generations past, we always had in the Osage a strong solicitor's presence at the table with our strong legal presence so that our leadership could have that valuable contribution of experience and legal intelligence to keep us from these frays that we're into now that are so dividing for this whole county. And there's more, it looks like there's even more in our future. My question is, you bring 13 people to help us in your agency. I'd like to know if any of those people, first of all, are the solicitor's office that could be permanently positioned in Pahusky agency. And what is the experience of those 13 positions where they can help us, help you do a better job of maintaining your trust responsibility?
I guess to the first part of the question, right now we don't have a solicitor in our agency office here at Osage. Regarding the experience of the staff that's been come on board, you know, I don't have all of their resumes and everything in front of me, but I do know, we brought somebody in on the environmental side who's had extensive experience in both the regional office and at the agency office now. We have hired somebody from EPA with extensive environmental background. And so we are working on that. And then in addition, we are providing training that we've never provided down here to our agency staff to try and ensure that they are better equipped to handle the issues that are in front of them. And I guess another point that I'd like to clarify and make sure everybody understands is, due to the judge's orders that stayed the implementation of the new regulations, we are under the old regulations, and we will continue to be and continue to operate in Osage County. And as I stated in my opening statement, we have prepared the EA for the We've been working with companies on EAs for APDs. We have prepared the programmatic EA for the workovers and those type of activities. So we are working to continue operations here at Osage County. Have a question?
I think we were talking about an enforcement issue earlier from the AG's question and the assistant chief's question. So my question that's not related to a lawsuit is, what does the Osage agency, what level of enforcement capability do they have in the area of mining our minerals here? What authority do they have to enforce the rules and regulations? I'm unclear on this because enforcement seems to happen differently in the oil field than it does on the mining of other minerals. So I'd like some clarity what the enforcement capability is of the Osage agency on permitting and regulating our minerals.
I think it's fairly clear where we stand with the oil and gas activities that are governed by 25 CFR Part 226, and that outlines what our inspection and enforcement capabilities are currently. Regarding the, I think Chuck kind of outlined, we have certain responsibilities, and there's always the question between the differentiation between surface and minerals. And so I really apologize that I can't give you a more definitive answer on that question today.
Thank you, Mr. Black, for coming to visit with the Osage and the people here. I'm on the Minerals Council. We've met before, so two questions. Number one, the EIS situation. I know we've got some issues there as far as it was late, and of course I asked. And I'm interested to know. I'm a roll your sleeves up kind of guy, and here you're an engineer too. That makes me, hey, maybe we can come up with a solution. I'm wanting to know if there's a way we can go to work and try to figure out how a programmatic EA can be expanded a little bit to cover some of our smaller operations. Do you think that's even in the cards? And I think we could work with you to try to get that accomplished. I know this is a looming EIS situation. I stand by my vote. I don't think that's the best solution on the table. I think going forward with some workable solutions might be better, get our producers and get activity going back into Osage. If you could respond to that. And then the second question, August 10th we had a ruling in Tulsa. Are you personally looking at a change in faces in your chain of command? Or what's your feeling of the administrative process that brought the decisions to that location in Tulsa? Do you feel like your office could have done better? If it was me, I'd say, well, let's chat about it, guys, and let's see if we might need to reshuffle the way these people are looking at the Bureau from my perspective, looking downward. And I think that's a viable question, because I think with the ruling on the 10th, my personal feeling is administratively there might have been some short steps. Maybe you weren't aware of all the things that were. Are you interested in maybe looking at some different faces in your chain of command?
Go to your first question, regarding the EIS. That is part of the things I stated before, that we are working to. I'm sorry, I see people grabbing their ear. Is this better? Can everybody hear me? I guess that was one of the reasons that, if you run through a couple things, the EIS, one of the reasons we went to BLM and asked them to accelerate the effort for Osage County in the EIS is to that end, so that we can get that completed and keep things moving down here. And then that's also why we developed a programmatic EA for work orders. So that's another process that I apologize, it took us some time to get that developed. But at the same time, it's something that we are working towards so that we can make it easier while we are completing that EIS process. So, and then to the second part of your question regarding the administrative, As I stated, that judge's decision stayed the order, or stayed the implementation of the regulations, and right now, it's going to go through its legal processes. I always and I will continue to look at our staff, you know, our structure of our staff and the people that we have working on anything to try and make improvements wherever we can.
I appreciate, I'm sorry, just a follow-up. If we can, and you mentioned the EIS, you mentioned the programmatic EA. The way I'm going to summarize it is programmatic EA is for non-groundbreaking operations in the field. That's kind of my workman's knowledge of what's going on. So if we can expand that to, you're actually breaking ground for smaller producers, the marginal well guys, the things that are, you know, I think with some of the operations, it's needed. You know, we have some feedback from the industry, yeah, I mean, and these guys can afford to do that. But on the smaller side, you know, it's a devastating maneuver. So that's why I'm interested in you know, I'd like to see us expand that programmatic EA to start getting into some groundbreaking operations so we can, I think it quicken the step. I'm going to follow up with this. Is there a way we can turn our 30-day into a 20-day turnaround on our what we've got to do on the archaeological stuff? I'm going to challenge our nation if it's even possible. That way it gets the conversation going, but it also quickens that one step by 10 days. How can we get that maneuver going? Is that something you'd be interested in?
If it's not found or part of the statute or regulation that requires that time frame in there that we'd have to abide by, I'd certainly be willing to look at anything that we do to streamline our process. I have a question, the lady right here, and then I'll get back to you, sir.
Mary Lee Evans again, shareholder. And I've sat here and listened to all of this, and as I've read through the rules and regulations that we're trying to pass into our Osage County, I'm concerned. Have you all read those from front to back? I've tried to read those and read them and read them, and when I get to certain areas, it says this can't be done without permission of the superintendent. This can't be done without the superintendent. The superintendent says this. Who is the superintendent?
The superintendent is Robin Phillips.
I know.
She's sitting right here.
Robin, I just wonder how much experience you have in business and in oil that you could make all of these decisions for these guys. You know, you might have people in your office that can help you, but to put that in the rules that she has the ultimate decision seems to me very unfair to all of us. And all of us here are concerned about Osage County and oil. And I know that it's not just here. It's Syria. It's the government. It is the United States government. Keeps going on down to Oklahoma, goes to Osage, and comes to each of us. We've all got to do something about this. I think that Robin should be working with the council undoubtedly every day. She shouldn't have to be the one to make the decisions on whether he can drill or he can be penalized. We got to think about that the way that's written. If that goes through and it says the Osage, man, lady, you got a big job. And I know you do now, but we need you to work with the council. We need you to work with Osage County. We need you to help us. These people are all going broke. And that's not funny when you don't have any money to buy gas or you don't have any money to buy food. Now, it's important, and I think it's a real responsibility on your shoulders to put that in there and say she has the last word. Thank you.
Thank you for that comment. No, the gentleman back here.
Let me tell you the real world on these permits. Last year, to beat the August 11th deadline, I filled out 17 139s to work on these wells. 49 weeks later, I got them all back. I turned everything in. They wanted 3 pictures, the sign, the wellhead, and the road coming in. I sent them all in. 49 weeks later, I get them back. Now they want 7 pictures and they want latitude and longitude. We've had a pretty good kick in the last 10 months. I don't have money to go out and pay somebody for latitude and longitude on wells that have been there since I was an infant. It's kind of silly. You can drive right to them. And I know what you're trying to prove up with latitude and longitude, but they've been wells of record forever up at the BIA. And maybe they're a little bit off, but to wait 49 weeks, and now I've got until, I think it's the day after tomorrow, to come up with 4 more pictures. I'm supposed to stand at the wellhead and face north and east and south and west and send those in. Like, that's going to help this? That's the real world on this permit.
Thank you.
I don't really have a question. I've got a comment to the oil producers. I was on a negotiated rulemaking. I sat in every meeting till I was sick of them, listening to these changes that we might want to make. Some of them I didn't like, a couple of them, but we weren't allowed to vote on the ones we liked. We voted on the whole change. Me and these two gentlemen right over here voted for it. So I'm just trying to tell you, I wasn't elected by the oil producers. I was elected by the shareholders. And I was elected to make them more money. And these CFR changes, the ones I voted to approve, NYMEX pricing, accountability, things like that, was going to make them more money. Made the producers mad, and I've been ridiculed for it and everything else. But I made the right decision for the shareholders. And I hear somebody behind me telling them they're about to go broke because of these CFRs. They're not even implemented yet. How are they breaking you? When they go into effect, it might hurt some of you. But right now, how can they be hurting you? They're not even in effect. We're still under the old regulations, what you drilled under to begin with. So I don't see your point in saying these CFR changes are busting you. I think it's $30 something oil per barrel. It's got more to do with it than the negotiated rulemaking done. They might hurt some of you when they're implemented, but right now they're not implemented. So I can't hardly sit here and listen to people tell them, oh, they're breaking us. We've got to go out of business. As far as I know, production is still the same.
Of course it's hurting us.
I don't see anybody shutting wells down and leaving.
Really?
But I just want to...
I lost my job over this, sir.
Well, okay, here's one right here. Have you left?
Mark's going to be shutting his wells in.
Because of the CFRs. That's what I'm trying to tell you. I don't know about oil prices or this EIS. I'm trying to tell you the CFRs have nothing to do with him getting busted or going out of business. They're not implemented.
We can't get permits to work on the wells.
According to Mrs. Phillips, we were supposed to start implementing this from day one. And we've already started doing it. I've started replacing my electric lights. I've already replaced my valves. I've lost investors.
Okay.
All right? Yes, it hurts us.
I feel sorry for you. You better get in the restaurant business or something.
Really?
Yeah.
Wow.
You should never be elected for crap.
If I may, this isn't going to get us anywhere to argue over this. This is, I appreciate Mr. Abbott's opinion, but I do have another question. The superintendent has the authority to issue fines for different violations up to, I think, up to exceed $500 a day. Is there a minimum fine?
Are you referring to the existing regulations?
Yes, the existing regulations. Is there a minimum fine?
I'm not sure if there is.
I know she has the ability to fine us up to $500, but could the fine be set at $1?
Generally, I believe the regulations call for that to be at the discretion of the superintendent.
Okay. Excuse me for interrupting again, but is it possible that that we could have a violation and the superintendent just not fine us?
Well, I think, you know, the process generally is you're put on notice in some cases, so there may not be a fine. Maybe
So we might could go ahead and acidize a well without a permit, which could be enforced and have a fine imposed on us, but at the discretion of the superintendent, she might have the ability to just, you know, not fine us. In other words, if we decided to go ahead and work on our wells, what we would subject ourselves to a fine by doing so without the proper permitting. Does she have to fine us? Can we, you know, is it mandatory that she fine us?
Well, what you're referring to there is taking an action more so than compliance. And taking an action would be subject to probably different actions than a fine.
Okay, is it mandatory?
We would have, that would fall into our case responsibility to the minerals estate.
It would be helping the mineral state. It would be helping the mineral state if I acidize my well and put it back on production. So it wouldn't be harming the shareholders. In this instance that I'm talking about, for the well I've got up the road that's got the stuck pump in that I want to fix and get that barrel of A back going again, it's going to help the shareholders, of which I am proud to be one shareholder. That would help the shareholders. So if I was to go about my business and subject myself to a fine, my question is, does the superintendent have to fine us? Is it mandatory that she fine us?
I think depending upon the regulation that this would comply with or relate to, we would have an obligation to take some action, yes.
Well, could it be just a letter saying don't do that anymore?
There again, you're not talking about a compliance issue, you're talking about taking some kind of action that would fall outside of compliance issues. So it could be a very different action.
Okay. If I was to go out and acidize my well tomorrow without the proper 139 intent approved by the superintendent, what are y'all going to do to me?
Let's just say that we wouldn't advise anybody to not be in compliance with the regulations.
Or what? What if the all went out and worked on our wells? What are you going to do to us?
I have a follow-up question from my colleague, Tali, and even two from Mr. Rebord, so that he doesn't have to be not in compliance. I'm curious if the situation you talk about with acidizing as well. This is one that needs to go out into the formation of ways, otherwise he doesn't even need a 1039, if I understand it right. I'm Galen Crum with the Minerals Council, by the way, for the listening public. We have a programmatic EA in place at this time for workovers. Mr. Reward states that his well has been maintained. It's not been allowed to go back to nature. It's been taken care of. It's on the same spot. Let's say this is my well, not Mr. Reward. Let's just turn it out of Mr. Reward and put it on to me. I'm a producer and I have this well I wish to do.
I'll show you.
I'll tell you what, the way you guys all talk about one now, I'm thinking that I should resign from the Minerals Council and get in. But it's like a buying time for me. What would I have to do in order to do that? I understand I have to take 7 pictures. But let me have you answer what it is I need to do to get that 1039 to do that acid job. A while ago, I thought we had the opportunity to do that when we passed because of legal questions. I'm hoping I'll ask it in such a way that it can be answered, because we answer them in the Minerals Council at times. This very question, what do I need to do to get that done? As a producer who has a well maintained, what's my process to get a 1039 or 139 to get that done?
Basically, you would submit a 139 with 7 pictures.
We've got a programmatic BIA that we will use.
So I can get one.
Yes.
And is the time frame on this really slow getting it out? Does there need to be a 30-day comment period on this? No comment period. I go down and apply and I've got it within the time it takes for you to process my tip 139.
It's first in, first out. Everything's by date.
Okay, first in, first out. We did have a backlog of them. Okay. But the backlog of the ones that have all their pictures taken, are they gone? Robin, I ask you a question. The backlog, we had a backlog of applications come in, kind of a flood, like what the gentleman back here referred to, that he sent them in a whole bunch at once. All the ones that have the proper pictures all went out. Is that correct?
Yes. I had to go back to Janine, because Janine has been really instrumental in helping with the process.
Okay, so that backlog is gone. What we would have is new ones that either need more pictures or people who hadn't decided to do anything yet and are like myself now, I'm talking about me, that I would be brand new going to apply for.
Correct. For a complete application would be a 139 with 7 pictures.
Okay, I think I might be able to do that if I was producing.
Another comment about the negotiated rulemaking. We put that in there where the superintendent has that power. And the mineral council has the same power too. Turn something down if we don't want it. Her power is so these CFRs, they're not set in stone. Just like this gentleman said, how much can they fine him? She cannot fine him nothing if she wants to. That's why we put it in there, for her to make that final decision. So if she don't think it warrants a fine, she can overlook it. Any of them, she can change. That's why we put that in there. And then in the same instance, the mineral council has to approve these. And Ms. Phillips has to approve it. That's why we put it in.
Well, that's what I've been saying. How can the superintendent have all of this authority to hurt all these thousands of people? I just don't understand that kind of a rule. And how much experience do you have in business and in the oil industry, Robin? Are you just politically?
No, she's not. She was selected for the position. She's previously served over the Anadarko Agency and has an active oil and gas operation there as well.
What'd she do there?
She was a superintendent there.
I know she's a superintendent, and I keep seeing in the rules that she has the last word. This doesn't seem fair. I think our Minerals Council has the right, and I think there should be a committee or something. One person can't do all that, and that's probably why she's so behind in her work. How many applications are still in the office not taken care of? 400? 600? You don't have any idea?
I don't have those numbers with us today.
Well, that's important. You should be able to keep up your work if you've got the job. Thank you.
Another question, Vice Chair.
Thank you, Mr. Principal Chief Raycorn. I wanted to address Mr. Bass. I think you can probably take from questions you asked, there was a lot of disappointment that there wasn't something physically done to stop the windmills. But let me balance that huge disappointment with how thrilled lots of us were that U.S. Attorney's Office, especially Ms. McClanahan, she's a great way with words, went after them in the courts. Do we wish that something more had been done up front to physically stop them? Absolutely. Absolutely. Were we happy that at least the office took it upon themselves to take that trust responsibility seriously and go after these guys with what I consider guns blazing? Yes. So I didn't want you to go away from this meeting thinking that we were unappreciative of what that office in particular, the U.S. Attorney's Office, has done in doing what they can. And from the tone of everything one can read, you're dead serious about bringing these guys to heel. As a final,
that's correct.
well, I want to acknowledge that. I also want to say that this entire conversation, this one conversation, may expose some measures that the BIA may want to put in place, or the regulations need to reflect that how important the mining part of it can be compared to the oil and gas part of it. And maybe that's something that we can improve in the very near future. Thank you.
Thank you very much.
Thank you.
Got a comment right back here, gentleman, for sure.
Hi, I just wanted to get some definitives. Some of the oil people here are asking questions about, okay, we're operating under the old regulations, and it's taking 49 weeks to get our permits. And I believe that's a change from what used to happen. So, and someone asks, well, how many permits are there that are still pending, so that these people can have an answer to, well, how long is it going to take for them to get their permits? And we're not hearing those answers. So for me, I'm looking for some definitives. I'm surprised we don't know here today how many permits are in the process and haven't been completed, and we don't know how long it's taking those permits. So could you answer some of those questions? A, how long, if you turned in a permit today, complete, how long would it take for it to go through? B, how many permits are pending? And how long can we anticipate that those will take? And C, if you've got to get your pictures in 4 days, after you get your pictures in, how long will it take for that permit to be completed as of today?
Yeah, I'll do my best. As I say, we developed the programmatic EA to help the 49-week process. I apologize that ever had to happen, but hopefully that won't be the future moving forward, to develop the implementation of the programmatic EA. And as far as the number of permits and APDs that are pending right now, again, as I mentioned in my opening statement, that's another lawsuit that we're under right now from the producers challenging our handling of the APDs in the NEPA context. So I'm not going to be able to respond to a lot of that as far as the exact numbers and those kind of things, because they're, again, that subject to pending litigation. Sir?
Mr. Black, thanks for coming today. As far as the process to get a permit, I'm Travis Keener, Hydration Engineering. We see the ABB as one of the hardest things to predict. There's a limited time in the summer when we can survey for it. Then we have to wait 60 days for the Fish and Wildlife to respond to the BIA for our permit. We've done some research on this. And with Secretary Order 3206 that says Indians cannot be disadvantaged when it comes to the Endangered Species Act, because it's underneath the Department of Interior, because the Tulsa Fish and Wildlife has taken, it appears to be the most strictest stance in the nation on how they implement the rules. There's other states that have a 3-acre minimum. As long as you're not messing with more than 3 acres, you just go on. Some states it's 1.2. There's a resolution that's been passed by the Minerals Council that would help with this, but it looks like that if we could just talk to since it's all underneath the Department of Interior, with your help, if we could fast track coming to an agreement that, for example, if we don't use more than 0.1% of the acres in Osage County, which is a very small percentage, and say as long as we don't mess with more than that, we would not be affecting materially the ABB. It's already trying to be delisted. A lot of the studies show that it's not endangered. It's just going to take a while to get off the list. But faster than all that, if your office could help with that, that could make a huge change in permitting, because right now, as soon as the temperature this week drops below 60 degrees, nobody can do an ABB survey until probably next May. And so nobody could, no matter how hard they work on getting a permit, they won't be able to do it under the current regulation until next year. And that would be just something we would really appreciate if you could help on that. Because if Tulsa would just agree to change that, it would immediately allow us about 1,400 acres that could be used, the 0.1% of the acreage, and free that up instantly. And that would be a big help.
Great, thank you. I am well aware of the American Bearing Beetle, or ABB, issue down here at Osage County. And we're working to try to open conversations with Fish and Wildlife to see what we can do, since they are the governing agency of that area. We will definitely look forward to trying to move that forward again.
Hello, Mr. Black. My name is Shane Matson. I'm the president of the Osage Producers Association and also a producer in the county. On the American Bearing Beetle, at the meeting that you had in May with the board of directors, we asked for some support in finding a resolution to the ABB similar to that which the ranchers that run wild Mustangs received from the Bureau of Land Management, which was a $2 per acre permanent take. What Travis is pointing out is that the American Bearing Beetle season is over. If you didn't get a survey in before, say, the end of this week, you won't be able to permit a well unless you're willing to pay a $15,000 per acre take on that well. We had this conversation in May. You indicated that you're still working with the Fish and Wildlife. Could you give us some flavor of how those conversations are going?
You know, I don't know that I can give you necessarily a flavor. It's just trying to open the discussions with them and evaluating some of the, like you said, the BLM, how they're handling it, you know, with their issues, and seeing if there's opportunities for us to enter into similar type arrangements. So right now, I'm hoping that we can move this forward.
Okay, thank you. Watching the last year in Osage has been one great heartbreak for me, and for many of us in this room, many of us in this county. And it's there's no shortage of issues that the county faces. Because of the number of issues and the magnitude of them, it's easy to lose sight of which issue is causing which pain. The July 2014 letter from the superintendent that changed the permitting process for new wells and workovers has left the industry reeling. In the in the August meeting of the Osage Minerals Council, accountant Jim Swan gave his monthly production. Production in the month of July of 2015 was 13,089 barrels. In July, that's per day, in July of 2014, it was a little over 13,500 barrels per day. If you look at that drop over a year, it's not that significant, which leads a lot of people to ask the question, well, where is the pain if the production is the same? Well, shortly after Jim Swan's presentation, Tom Lackey of Chaparral stood up to give an update on the production changes at the North Burbank unit, which is a several $100 million investment project going on the Burbank unit, where they're injecting CO2 for the tertiary recovery of the oil in the Burbank sand. Over that same period of time, July 14 to July 15, the North Burbank unit went from 1,200 barrels a day to 2,600 barrels a day, an increase of over 100%. If you back those numbers out, county-wide production, year over year, excluding the CO2 production, is down 15%. And it's that drop in price that has left us reeling. That drop in production that has left us reeling. You couple to that the drop in price, and we are at a crisis. The shutdown of the permit process for any amount of time in the oil and gas business is dangerous business. We probably lost in this county $50 million worth of workovers in that period, and easily $100 million in new wells that have been drilled in that period. This is a significant value that the Osage shareholders have lost in what would probably be 1 million barrels of oil that weren't produced. That's an easy number to get to. 1 million barrels a year, 1 million barrels in 1 year is not a hard number to achieve, but you've lost in excess of $100 million of investment in the last year. We need relief.
Thank you.
was just looking up, trying to use the internet here. The Office of Inspector General report in October 2014 is a document I handed Secretary of Interior Sal Jewell last year, and she had not read it, and I haven't talked to her about it since. That is a document that some of you recall says the Osage agency needs sweeping reforms. It's an important document, and I would ask you to address what the Bureau of Indian Affairs was doing in response, particularly to that Inspector General.
As the Chief stated, and I stated earlier, in October 2014, the Office of Inspector General issued a report about the Osage Agency and the BIA's management of the Osage Minerals Estate. And they identified approximately 37 recommendations in that report that they felt should be implemented by the Bureau of Indian Affairs to improve our operations. So part of that process for us within the Bureau of Indian Affairs and the department is we have to go through every one of those recommendations and identify what we are going to do in order to meet those recommendations. So we are in a process right now looking at all of the recommendations. Well, I shouldn't say in a process. We have been in process since October 2014. We've just recently closed about, I want to say 4 or 5 of those recommendations that we've been able to implement. And we will continue to do that, and it's all on the schedule working with the Office of Inspector General. So we will address each and every one of those recommendations and make the changes in whether it be our policy, operations, or staffing to ensure that we are able to implement the recommendations and meet what the Inspector General felt would improve the operations of the agency.
All right. Well, here's our time for this room is up today. And I'm not sure where we're going, but I do know that we're going to have to work together immediately. We're going to rely, the government that is, of the Osage, on our Minerals Council to work with the producers. The Bureau of Indian Affairs role is changing. There's absolutely no question about that. Assistant Chief Redcorn and I are going to take your lead as the way we go, Mr. Chairman of the Minerals Council. We want to support that direction. I really like the idea that the Osage Minerals Council can handle a lot of these duties instead of the federal government. And we certainly are not going to tolerate the state of Oklahoma doing it for us. And we are united on that. Record Black, despite all the problems, we want your assurance that the trust responsibility as set out by the Congress for your agency will continue. You said there is law that says you will in perpetuity, as Stephanie pointed out. Can you assure us today that everyone, all these lawyers and everybody is going to make sure that the federal trust responsibility remains intact? Yes, I can do that. Well, yes, it's got internet. Yes. Yes, sir. I can assure you that the federal government, the Bureau of Indian Affairs, and the federal government will continue to maintain our trust responsibility to the Osage Nation, the Osage Minerals Council, and the Osage Minerals Estate. Well, we have a long way to go. Mr. Waller, it appears that you're in the lead, and the Office of the Chiefs, and I'm sure the Congress will support this. I want to again thank you for coming to visit us. I look forward to seeing you all when you come back again, and thank you. And I think as of this time, we are adjourned. Thank you.